Oh, hey guys, my mic is on already. Hi guys, it's Kathy. I hope you're doing well. I'm talking quietly because I don't want to wake Hope up. She thinks that she's just resting her eyes for a second, but she's out like a light. Yeah, Kelly, you're thinking too much. Think about puppies. Hey guys. Anyway. Oh wait, you don't see it yet. Hold on. I have cats for sale if anybody wants them. I'm selling them. That's it. I've had enough. They treat me like crap. They bully me. That's it. But don't anybody buy them, please. They're mine. They're mine. Oh my gosh, guys. J Fire is here. It's it's backwards. Are you kidding me? Because I just spent 20 minutes mirroring it so it would be the right direction. Hold on. Hold on. I'm gonna put a video on and fix it. Oh yes, I am. Yes, I am. Let's just go. Whatever this first one is, you're watching it. Here we go.
Psychologist.
Wrong. I just told you you can't do that for up to 6 months since I've been in class. You cannot do that for 6 months. Are you aware of this? I'm a public defender. You cannot do this for up to 6 months since
Mr. Keller, I'm happy to listen to anything you wish to tell me, but
I'm not going to accept anything. You're going to say I'm being found incompetent. You're weighing me for competency again within
Mr.
6 months of being found competent in the mental hospital stay.
Mr. Keller, I'm not yelling at you, so please don't raise your voice at me.
I'm telling you sternly because I'm an officer in the U.S. military.
I will give you the floor in a moment, but first,
You're going to weigh and pen me. You're going to weigh and pen me into this conversation bent case. And someone who is law here, are you law?
Mr. Keller, you do not get to talk to others in the courtroom when I'm speaking to you.
Okay, Your Honor. You're not being honorable, sir.
Hold your tongue and listen. Since it is the defense that has raised the issue, it constitutes a waiver of privilege to any previous or subsequent competency evaluations. You have the right to remain silent during the evaluation. However, such silence may be used by the evaluators to determine your competency. Any statements you choose to provide in cooperation with the evaluation may be used by the prosecution as either impeachment or rebuttal evidence if you testify at any subsequent criminal trial. Any statement you choose to provide in cooperation with the evaluation may be used at any sentencing hearing held in the case if you are found guilty. You have the right to request an evidentiary hearing to contest any determination of competency. You have the right to be examined by an expert of your choice on the issue of competency. A copy of any report generated by that expert will be provided to the prosecution. At such hearing, you have the right to be present in person, to examine any reports of the evaluation or other matters to be considered by the witnesses called by the court, to introduce evidence, summon witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make an opening.
You'll never find me. You'll never find me, security.
Statement and closing argument. If you are found incompetent to proceed, then the criminal proceedings would be suspended and you would be committed to the Department of Human Services for a period not to exceed the maximum term of confinement that could be imposed for the offenses with which you are charged. If committed, you have the right to request a hearing as to whether your competency has been restored. If you are found to be restored to competency, then the criminal proceedings will resume. Do you have any questions for me about any of these rights?
This is my legal tractions about trial.
Say that again.
These are my legal tractions about trial you're discussing.
I'm talking about your right to contest any finding of incompetency. I'm talking about your right to hire a psychologist of your choice to contest any finding of incompetency.
I'll hire a psychologist of my own choice. This is going to be the procedure asked.
I'm talking about your right to remain silent during the psychologist's evaluation of you.
Okay, well, then they'll be the only privately hired psychologist. You say, I want to do this mental health review?
It's going to be conducted at the county jail.
Right, I'll be hiring my own psychologist then.
All right. The court hereby orders the Department of Human Services to conduct a competency evaluation of the defendant. This evaluation will occur at the El Paso County Jail. The court will review this case in 90 days to check on the status of the evaluation. That date will be August 16th at 8:30.
Sorry,
13th at 8:30.
Excuse me, Your Honor.
Yes.
What is your disclaimer about this difference? What is your disclaimer about this difference?
The difference?
You're talking, there's a difference here for a review. Like I was telling you earlier, there's no possibility that I should be reviewed for a mental hospital discussion of competency. I didn't finish my case. What date is trial going to be set for right now currently?
Mr. Donnelly, are we even on the trial track yet?
Then how am I being waived for incompetency if I'm not on the track for trial?
You don't
I
even
just
know
got
what
back
that
from
means.
competency. I'm competent to proceed in this case. We decided this last time I was here. What has been the difference that has caused this issue?
Time has passed since that first evaluation.
J-Fire, I will give you a competency exam. Everybody in chat, make up a question list and I will give it to him.
Things have changed.
Well, I just got back from mental hospital, said I was competent. And the last time I was here a month ago, we all decided that I was competent to proceed in this case.
I'm fully aware of that, but things have changed.
What has changed? That's the difference I was
Your
asking.
attorney has tried to meet with you, and he's required by law to formulate a judgment about your ability to assist in your own defense and to understand the nature
Well,
of
it's
the
not like-
proceedings and the charges against you.
It wasn't necessary to meet with him, I thought. If it was so necessary, I would have met with him.
He has filed a motion. I have found good grounds for him to raise the issue of your competency again.
That's
And
not
I'm now
within
ordering
6 months. That's an illegal fact.
I have now ordered another evaluation. That date again was August 13th at 8:30. We'll see you then. Thank you.
I feel. Whoa, dude, get off me. This is illegal as hell. Get off me. Stop putting me in his hands. Stop putting his hands. Now, get off my fucking arm. You're an illegal person. You know that? You're going to jail. It's just. Military conduct and police.
He said a bad word. The poor judge. Look where I left him. Oh man. Okay, we're going to California next. This guy has some cojones. Let me tell you. This guy has some nerve. I'm just saying, this guy has some nerve.
It's right there. Okay, correct. It's us doing. It's gonna be Sean L. King on.
Calling case number CR 246634, people of the state of California versus Shondell King. Mr. King is here in court this afternoon. Is the public defender's office available for appointment?
Yes, Your Honor, and I can confirm the statistical information on the complaint is correct. Waive formal reading it as advisement of rights and enter a plea of not guilty. In regards to his custodial status, we are requesting that the court release him on his own recognizance. He's indicated there's no amount of bail that he can afford. He currently lives in Newman. He is
Yes, and I have change for $1. Don't worry. That will be your next question.
lived there all his life, so he has strong community ties. He currently has a full-time job at Caltrans that he is at risk of losing if he were to remain in custody. He does help take care of his parents and he helps them pay their mortgage. So they would also be at a detriment if he were to be in custody and lose his job as well. He's indicated he can transport himself to court. He does have some open cases, but I don't believe he has any convictions. And I know in those cases, he has been showing up to court while on his own recognizance and has had no issues with that. And so for those reasons, we're asking for him to be released.
Maybe the people can confirm, but I saw a conviction just in May of 2023 for PC 148, and he's on informal probation.
That's correct, Your Honor. And if the people may be heard on this particular case as well.
Go ahead.
So the victim in this case is Newman Police Officer Pacilis, who was waiting in these very hallways to appear on a preliminary hearing in another case that Mr. King has while waiting to testify in that case, Mr. King here elbowed him on purpose, essentially attacking him, causing this case to be in front of the court here today. The people want to bring to the court's attention that if this had not been an officer, if this had been a regular civilian witness, the charge would have been a lot graver than at 243, which we're charging him with right now.
All right.
And if I could just briefly respond, I do understand the court has to treat the charges as true for the purposes of bail review, but I would just note that this was dropped down to a misdemeanor, and I don't believe there were any injuries, and with that, I would submit.
All right. Well, I did look at this defendant's history. I did note bench warrants in 2005. I know that's quite old, but as recent as 2021, 2022, I did note the misdemeanor conviction again for that PC 148 with the informal probation just in May of 2023. The jail set this at 25,000, I believe, because of the felony potential, but it was a drop down. I am not inclined to grant OR. I am concerned regarding the public safety as well as the safety of potential witnesses, understanding that this was an officer at a preliminary hearing as alleged. It is very concerning to the court, understanding that Mr. King was or is on informal probation, so the court is concerned regarding his ability to follow court orders, including to be law-abiding while on probation. And this defendant's likelihood of attending future court proceedings. So at this time, denying the request for OR, I will set it at schedule though at 5,000 instead of 25,000, which is in lieu of the felony, but a misdemeanor. So I'm taking into consideration that this is a misdemeanor charge. And I'll set this over in due course. Is that what you would like?
Yes, if that's the soonest we can come back, and I just asked to notice for a bail review at the next court date.
Well, I can set over for 2 days if you want.
I would ask to do that just because since he's got that felony case, they may want to deal with that as well if he's going to be in custody.
So then 2 days for bail review and see.
So, David, I'm very, very, very impressed. I just need to know, are you married? Because that's like way better than half the people I've ever, never mind. Sorry. This guy hit a police officer in the courthouse. What an idiot. Okay. This next one is 3.5 minutes long, but it's going to feel longer. And you're going to wonder why. Why? I don't understand why. Hi, Iowa. Hi. Here we go. I mean, why? Here we go. I mean, the judge doesn't want to. So why? Okay. Anyway, here we go.
He's a hard worker trying to improve himself by getting certificates. He's a high school graduate. We would ask for him to have a reasonable bond so that we can fight this drama case on the outside.
Judge, and we oppose bond. We do believe he's a multiple-time felon judge. I mean, multiple time. The cycles I was counting was 18, but I see, multiple convictions for multiple felonies, including felonies of violence, Judge.
We will miss you.
Here, this isn't just a case of drama. I mean, he choked this lady to the point where he left marks on her throat that the officer could see, Judge, and he choked her in her own home. Then tried to cover up her screams, to conceal the fact of what he's done, Judge. He's violent. He doesn't need to be let out, Judge. And I think that, and it's a lot with cases like this where we got people all of a sudden, just a violent attack, and then all of a sudden they want it dismissed. I wonder how much of a play he's had in getting her to write us letters saying it needs to be dismissed, Judge. I'd say that bond needs to be denied, Judge. And I believe he's out on bond on 24 FE 0125 as it is. That's a JH case.
Is he on bond for another case?
Are you on bond for another case? What are the charges?
John. That's how they sign up here. That's the case he's got pinned right there.
He believes that he might be on bond for another case, but it was a case involving the disciplining of children.
John. Here
Yes.
they do it by judge.
and we would ask for a reasonable bond. This county doesn't have enough money for every single person that has drama to be sent in jail indefinitely.
Well, I would agree with you there, but there's only so many times that the drama excuse can be used, right?
No, I see it every day, Your Honor.
Well,
It's my entire caseload.
after hearing the proffers and considering the factors required of me,
The phone is
same with bond, $20,000. Stay away from the victim and her property.
I didn't hear the amount, Your Honor.
$20,000.
1,000. All right. Thank
Stay
you.
away from the victim and her property. I understand the allegations that may have been a mutual residence, but it's not anymore.
Yes, Your Honor. We'll make sure he finds somewhere else to live.
I stopped it because I don't want to hear that lawyer no more. What do you mean set him a bond? You obviously don't want to set him a bond. He sat there and thought about it because he knew he didn't want to give him a bond. Set him a bond. Okay, so the bond is $20,000, and that's a lot. But he still gets a bond. I don't know why. I just don't know why. I don't know why. Anyway. Listen. Oh, I wonder if he's married. Anyway, no, Carolyn, no. I can't fix him. Well, okay, honey. She does have a strange desk. However, that desk is grandiose compared to a lot of the court reporters. I mean, grandiose. Like she can actually, has sides and everything. High inner point. And yes, it's really hard to do that, but Carolyn sure did, didn't she? I found out that chrysanthemum, Carolyn, sounds like I hope I'm not saying something bad. Oh no, I can't remember the word. Not an Aussie, but oh no. I was gonna tell you this and I forgot the word. Listen, while I try to think of the word, um, that's on the tip of my tongue. Oh my gosh. Anyway, I want to thank some people for supporting me on Patreon. I really appreciate it. The newest people, Vicky May, Lori DJ, which stands for De Jesus, but I think of it as DJ. Spin those records. um, Laurel Torkson or Laurel. Oh, Gen X got it. Gen X saved me. Thank you, Gen X. It's Kiwi. The lawyer is Kiwi and the judge is Aussie. And that's not a bad word, right? I didn't just insult you, did I? Kiwi? Kiwi's not bad, right? The fruit. Fruits are good. Doctor says fruits and vegetables. So for some that cause cancer and others make you fat, but fruits and vegetables. Thank you. I absolutely trust you guys. Not kiwi. She is not kiwi. What is kiwi? Kiwi is a bird, so that really could be an insult. Because when I give someone the bird, it's nothing nice. New Zealand accent. Got it. Hi, Jacques. So I'm going to need to speak to someone from New Zealand. I also found out that other judge that we had the other day that I said was a New Jersey accent isn't a New Jersey accent. Apparently, it's a Long Island accent, which is New York. And the other people there were New Jersey. But anyway, Anyway, look. Can you see my robe? It's a TARDIS. I'm wearing a TARDIS because it's bigger on the inside. You should all get TARDIS robes. Okay, this brat next just like he got so freaking lucky, and he's such a brat. And his mom is gonna clean everything up for him. I know it. I didn't put the whole thing on because it was boring. I just put the beginning on where he was a brat and then got something great happen to him.
Well, I think he called me, but I don't know that he's applied for this new case, or is it just?
It is. Is he private counsel? Are you private counsel in his other case? Or are you ADC?
I'm private on his other two, yeah.
Okay. Have you been retained in this matter or no?
Not yet, but his mom has called me and talked to me.
Okay. Do you want me to just represent him pro se then?
Sure, for now.
Mr. Hamilton, it doesn't sound like you've retained Mr. Allen, and like we talked about yesterday, unless you retained him, he doesn't have any obligation to represent you. So do you want me to advise you of the rights that you have in your case, or do you want more time to formally retain him?
What do you mean retain?
He has to be paid money, and you probably have to sign some paperwork so that he can represent you in the case.
Oh my God.
Or just an agreement, Judge, would be fine with his mom. So I don't think that's that crucial, but we didn't talk about it. We did talk about his case, though. She called me at 5:30 in the morning on a Monday, I think. So.
I can't make Mr. Allen represent you as private counsel, Mr. Hamilton.
All right.
So do you want some time to formalize an agreement with him and have him represent you? Or do you want me to advise you of your rights, the charges in the case, issue a protection order, and set the matter out to a date and time that works for you and Mr. Allen?
Well, what's going on right now? I have no idea what's going on. I thought we were doing like a bonds thing.
So you can be advised. Protection order will be issued after I advise you of the rights that you have in your case and the charges in the case, potential penalties that could be imposed. Issue a protection order, and we can address bond if you'd like. But Mr. Allen's not going to represent you. So if you want time to formally retain him, like I said yesterday, I can give you time, or you can temporarily waive your right to an attorney, and I can do that without an attorney participating.
I guess I'll wait.
Mr. Allen has another case. Mr. Allen, do you want to set this tomorrow at 1 o'clock? Do you think that's enough time? Or do you want to set it on Thursday?
I think my hearing's tomorrow at 4:45. Or do I have a 1 o'clock tomorrow?
No, but I have a 1 o'clock. We have 1 o'clock jail advisements.
So would that be okay with you, Andrew, if we just did this tomorrow, 1 o'clock, or do you want to do this today? I'll just jump on board, Judge. We'll be fine. We could just do it right now, impromptu, and I'll work out the rest of the arrangements with Andrew's mother later. And so we can at least get him advised today and maybe talk about other matters relevant to his case.
Well, I don't want to put you in that position. And I don't want to be in the habit of putting folks in that position. It's not your obligation to represent folks who haven't formally retained you. And I think most attorneys would not represent someone until money was in their hands.
I'm good with it because I've talked to his mom. I'm on board his other two cases. I talked to Andrew. He called from the jail. So I don't think there's anything surprising right now.
Do you waive formal advisement? Have you seen the affidavit and support warrantless arrest?
No, but I know of the charges and a little bit of what Andrew told me about and his mom told me, but I would waive.
I can't imagine a time where I would be in front of a judge and a lawyer would just say, I'll take care of this, even though I haven't paid him yet. Don't worry, I'll take care of this because, I spoke to her mother. First off, if they spoke to my mother, she would be asking for me to go in jail. No doubt. She would be saying, Judge, lock her up. Lock her up. I will pay you to lock her up. She would probably give me an attorney who she paid to lose. Oh, man. My mommy said it was okay, Judge. My mommy said it was okay. Guys, if you're wondering why, my, see? If you're wondering why my cats are for sale, it's because right before this stream started, they shut my computer off. Yep. Yep, they did. They shut my computer off. They just don't like me. I'm telling you, they bully me. They bully me. Okay, let's go. Oh, yeah. You know what? The next one I'm calling a cat fight, which is perfect after what I just said. No, no, don't chew that. Sorry. I'm sorry. I'm sorry. Don't. Sorry. Sorry. Anyway, hi, Debbie. Let's get into this cat fight.
And it looks like the first case is Brianna Hunter versus Aaron Culbertson. So, Ms. Hunter, you are there. And where is Mr. Culbertson? It would help, I think, if you raised your hand, sir, if you're here.
I'm a ma'am.
Oh, ma'am, excuse me.
Yes, ma'am.
Right? Sorry about that. Right. Yes, ma'am, you are. All right.
Yes, ma'am.
Let me get you. Move to the stage. Let me get Miss. It'll take me just a minute. I need Miss Brianna Hunter. Miss Hunter, wave at me as well so I can see you, Miss Hunter. There you are. Okay. Huh. All right. Okay. All right. So this is the case that of Brianna Hunter versus Aaron Culbertson. It is a stalking matter. Now, a few questions before we get started, and everybody else, I'm going to ask these exact same set of questions to every single person, every single case. There are no right or wrong answers. I just need to know. And Miss Culbertson, you need to keep your video on.
You said keep it on?
It on when we're doing your case. Yes, ma'am.
Okay. It's like if I don't move my screen, it kind of just disappears.
Okay. Well, let's try working on it, but I think we'll be okay at the moment.
Can you see me? Can you see me now, Judge?
Sure, I can see you now. Yes, ma'am. All right.
Okay.
So, Ms. Hunter, you're representing yourself. Is that correct?
Yes, ma'am.
And Ms. Culbertson, you are representing yourself.
Yes, ma'am.
Okay. So, Ms. Hunter, this what you got from the court was an ex.
So apparently, I get comments from people from New York and New Jersey, and they needed to go faster. So they play my streams later on double stream or speed or 1.5 speed or whatever. And they keep saying that when I laugh or giggle, it's so funny on double speed or 1.5 speed or however they do it. I think that's crazy. And that's how I watch almost all court videos. Double speed. I have to do it double speed. Or it's just way too slow for me. I can't keep focused.
A temporary protective order, which means that it was a different judge than me. And what would have happened is you would have come in by yourself in front of Judge Darden. And Judge Darden gave you this ex parte order, and that means, Ms. Culbertson, you didn't have a say-so in it. But now the question is, Ms. Hunter, do you wish to have that temporary order made into the 12-month order of the court? In other words, do you wish to proceed?
Yes, ma'am.
Okay. Ms. Culbertson, do you agree with an order going into place, or do you wish to have a hearing?
I would wish to have a hearing.
Okay, not a problem. Ms. Hunter, is anyone going to testify other than you?
Yes.
Who else is here that's going to testify for you?
Oh, you mean here right now?
Here right now at your hearing. Yes, ma'am. Nobody else? Okay. How about you, Ms. Culbertson? Is anybody going to testify besides you?
No, ma'am.
All right. In that case, we can go ahead and get started. If both of you will kindly raise your right hand, the clerk is going to come on and swear both of you in.
Do each of you solemnly swear that the evidence you shall give the court on the issue pending shall be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, thank you. Now, this is the way we're going to do this. And again, for those of you, particularly if you don't have a lawyer, just pay attention to this as well. What I'm going to do is I'm going to ask, starting with the petitioner, always start with the petitioner, the person who brought the lawsuit. So I'm going to start with Ms. Hunter. I'm going to be asking her a few questions and she's going to be telling me some things. While that is happening, Ms. Culbertson, you are not going to say anything. Even if you totally disagree with what you're saying, you're not going to interrupt her. You're going to just let her testify. When that's over with, you're going to get your chance and she is not going to interrupt you. Does that make sense?
Yes, ma'am.
Okay, and since you are each acting as your own lawyer, Ms. Culbertson, you will have an opportunity to ask Ms. Hunter some questions if you want to ask them, and we'll talk about that when we get to it. And Ms. Hunter, you're going to have the same chance to do that of Ms. Culbertson. So with that, Ms. Hunter, let me start with you. And so you are Brianna Marie Hunter, is that right?
Yes, ma'am.
Okay, and let me just double check. They are not part of Safe Shelter, right? I think I saw somebody, Miss Brianna, me, right? They're not part of your.
No, Your Honor.
Okay, all right, thank you. All right, so let me go find the paperwork here from your petition. In your petition, you have said, let's see here. Looks like it's kind of short. All right. All right, so it sounds like the two of you, Ms. Hunter, share an attachment of sorts with the same man. Is that right?
Correct.
Okay, so she and this man have a child together, and you are presently dating that same man. Is that right?
Correct.
Okay, and so what you're alleging is that she texted him that you have a nice house and that she was snooping through your things. Is that right?
This happened about 2 years ago. That's when the first situation happened, but that wasn't pertaining to the recent situation.
Okay, well, here's some more stuff. Here we go. And then, so that happened 2 years ago, and that sort of got you going or got you worried. And then it says here that she created a fake snapshot under the name of Holly Marie 24. The notification popped up on your phone. How did you know it was her? Because her name in my contacts is Junior BM. The snapshot notification had that name on it, saying that person from your contacts wants to be your friend. So in other words, she tried to friend you. Is that right?
Correct.
Okay, and then your boyfriend got a notification as well that stated new friend suggestion. So in other words, she was trying to friend you and you didn't want to friend her. Is that right?
Correct.
Okay. And so you said that, did that end the matter?
Yes.
Okay. Now let's fast forward here. I see another page and it says that on April 23rd of 2024, she violently attacked you and your kids at the bus stop.
No, she didn't attack my kids. She attacked me.
You, okay. You were sitting in your car waiting for the bus to drive off. She was sitting in her car. The bus driver was waiting for her to pass, but she turned right instead of going straight like she normally does and proceeds to drive up my car and roll her window down. I rolled mine down because I was seeing if she was trying to talk. Well, she then puts her car in park, gets out of her car, and then begins to pull your hair and so forth. You never once agreed to fight this woman. I have plenty of evidence from surveillance footage. Well, the evidence, if you don't have it here, let's see. So basically, she attacked you in your car. Is that right?
Correct.
What else you want to tell me about it?
About that situation about her attacking me in the car.
Yes, ma'am.
I was sitting in my car. She got out her car. She came up to my window, pulled me out my car through the window. She started fighting me, and as we were fighting, she kept telling me like, "Oh, I've been waiting for this. I've been waiting for this," and then after that, I attacked her back. Like I had defended myself, and then after that, she was just like, "I'm done fighting," and so. She got in her car. I got back in my car, and then she drove off. And then I had followed her to the gas station And then that's when I had called the police and did a police report.
Did the police take a report?
Yes.
Did the police make any arrests?
No.
Okay. Now,
but they said that if I wanted to press charges on her, I could, but I just never went.
But they had not seen charges. Okay. Now you included. Oh wait, no, this may be Ms. Culbertson. Okay. So, anything else you want to tell me about Miss Culbertson? Anything else Miss Culbertson do?
Yeah, she so ever since that situation happened, like a month ago, I thought everything was over and done with. Like, she hasn't said nothing to me, I haven't said nothing to her, blah blah blah. Then like a week ago, matter of fact, last Tuesday, mind you, ever since the situation had happened, when they do pickups and drop-offs or whatever, it hasn't been at our house because how they had it in their custody paperwork. She, when it was like her time to get them, she would pick them up from our house and stuff like that. But ever since that situation had happened, she was picking them up from his mom's house and then dropping them back off at his mom's house. It's been like that for a month, no problems. So then last Tuesday, out of nowhere, she was telling him she was gonna get the kids, and he was just telling her like, okay, like, you know, you can pick them up from my mom's house, drop them off at my mom's house. So she picks them up from his mom's house last Tuesday when it was her time to get them for like a couple hours. And so she was dropping them back off like around 7. And she was telling him was like, no, she wasn't going to drop them off to his mom. She was going to do what the court paperwork on their paperwork says, which is to like drop offs and pickups at mom and dad's residence. So she was going to come to my house and drop the kids off. And he was telling her way before she even had got the kids, like, don't come over here. You're not welcome over here. So she took it upon herself like around 7 o'clock when she was dropping them off. She drives all the way to my house to drop the kids off. Mind you, his mom and her live in the same exact neighborhood. His mom actually lives like 2 streets away from her. From her house to my house is like a 5 to 7 minute drive, depending on traffic. So you pick them up from his mom's house, but then when you wanted to drop them off, you came all the way to my house knowing he told you, don't come over here. I didn't want you over here. You still came over here and dropped the kids off. And then you was telling him, was like, no, she's doing what the paperwork says, which is to drop off at dad's house, blah, blah, blah. But for the whole month from that incident up until last week, when she was getting the kids, she was getting them at his mom's house, picking them up at his mom's house, no problem. And then last week, you just took it upon yourself, like you want to be petty and drop them off at our house. And then she was telling him, was like, well, whenever you come get the kids, or whatever, don't have her come into my house or whatever. And he was just like, huh? I'm really sorry, I don't know. I'm listening. But she was telling him like, oh, don't have her come into my house whenever you pick up the kids. And he was just like, okay, like that's fine. Like, I'll make sure she doesn't come. And all that conversation happened way before she even had came and was picking up, dropping off and all that. That happened like earlier on that day. And then like around 7 o'clock that night, you still decided to come to my house and drop my kids off after he done told you, don't come to the house. And and now I called the police because I was like, why is you being petty? Like, why is you going out of your way, like, to be petty?
All right, thank you. I think I get the lay of the land from you. Ms. Culbertson, what do you want to tell me?
Yes, ma'am. First, I would like to address the statement that she made saying that I said that she has a nice house and was snooping through her things.
Let's move forward. Let's move forward from that for right now.
Okay. So what do you want to know about first? The fight? The fight happened. Yes, ma'am. So when the fight happened the day, as you know, our kids share the same bus stop, so I was there for the kids. Once the bus had already left.
Why are you guys at the same bus stop?
Because her and my children's father live together, so they have the same bus stop there. Okay. Because yes, ma'am. So when the kids were getting on the bus, I had my head down looking at my phone. When I did put my head up, the first thing I looked at was my rearview mirror. And that's when I seen the bus already passed in my rearview mirror. That's when I looked forward and I seen Brianna in her car when she normally pulls off or she goes back home. So from the argument prior to the day before, after everything that was exchanged with the text messages that I provided to the court to prove that, it was mutual to me. So when I pulled up and I got out of my car, she had her window down and my words was, "What's up?" She responded with, "What's up? We can go to my house." So that right there and there told me, oh, you want to fight me just as much. So that's just where the fight started. And I did pull her hair and all that stuff. And then once we got up, she stated that I said that I was waiting on this. Judge, yes, ma'am, that's false. What I told her was, I'm tired of you. I'm tired of you. I'm tired of you. Those were my words. And in the report, she states that on the surveillance camera, you can hear her say, give me 1 second, Judge. You can hear her say, "Get off of me." Now, if the video footage was presented to the courts, you could have heard me telling her, "I'm tired of you. I'm tired of you." Now, prior to the fight, Judge, as I stated, as of like 2 months ago, I had already blocked Miss Brianna from my phone so that she couldn't contact me about anything that I said to my child's father, because what I say to him has nothing to do with her at all. Regardless, if I do mention her, you don't have to contact me about it. So I had already blocked her from the phone. After that, once the situation had flared up and she contacted me about something that I said to my children's father, she didn't like that. So she contacted me through Facebook Messenger. And once a couple of messages was exchanged, which was pertaining to the fight, I blocked her after that. After I blocked her off of Facebook Messenger, she then goes and uses her fake Facebook account that she used in the past to contact me, which I have evidence of that too, that I brought to the court. And she used that fake profile to contact my current boyfriend to talk to him and tell him about me. And she stated that since she blocked me, she was going to talk to him. And then that's when the fight escalated into the next morning. And then after the fight, she did follow me to the gas station. In my opinion, if you're scared and you need a protection order, you wouldn't follow somebody that you're scared of. So you followed me in your car. And when I got to my gas pump, because I went to the gas station to get gas, when I got to my gas pump, she parked her car directly behind mine. When I got out my car, I just went into the store to pay for my gas. I did not engage in another altercation when I could have. I had the space and opportunity to do that because she was right behind my car, but I didn't. Also at the fight, I stopped myself because I knew that nobody else was there to break it up. So I knew I had to do it myself. And again, after she called the police and all that stuff, everything was great. Apparently she had filed the TPO and I wasn't aware, but she was still pulling up to my house that she addressed when I told my children's father not to have her pulling up to my house. To me is, if you need a protective order, why would you come to the person's house after the fight that you're scared of? That doesn't make sense to me, honestly. So that's when, actually, when she was at my house, I seen her in the car. I did not engage in another altercation. I did not engage in another fight. I just let it be. Now, to the part where she's saying that I was doing pickup and drop-offs after the altercation, Dad was asking me, hey, can you pick up at my mom's house? Can you drop off at my mom's house? In my head, I'm thinking he's just out of town or he's in town. He's just not around right now. That's just where the kids are. So I was doing that until I caught on that he was constantly making me go there. And I explained to him that that's not court orders. Regardless of what you want or what she wants, I have to go by what Chatham County wants me to do. And that's what I did. When I pulled up to the house, I didn't engage in any fights. I didn't get out. I didn't start an argument or anything. I just kindly dropped off the kids and left and came back home. It wasn't about being petty. It was just, I have rules that I have to follow from a judge. So to me, that outweighs what he or she wants. And I did tell Dad, if you don't want that to happen, change your address, change your residence, whatever, we can figure it out. But other than that, that's all I really have to say. I don't really believe that a TPO is necessary, since throughout the processes, I have text messages that are provided where she's constantly reaching out to me about what I say to her boyfriend. Like, if I'm not talking to you, you don't have a reason to contact me. So that's all I have to say for right now, Judge.
Don't worry. You guys have all said almost exactly what the judge is about to say.
Thank you. All right, hold on just 1 minute, everybody. Here's what we're going to do. Let me take me just a minute here. All right, what I'm going to do, Ms. Hunter, I need you to put your picture back on. Ms. Hunter and Ms. Culbertson, what I'm going to do is I'm going to put a good behavior order into effect, and this means that both of you are under the following order. You are not to inflict any injury upon one another or cause damage to each other's property. You are not to get anyone else to do that. You are not to trespass upon the premises of the other. You're not to approach within 500 yards of each other. 500 yards is 5 football fields, so you don't come close to each other. I don't know how you're going to figure out the bus stop stuff. That's your problem. Get someone else to do it if you can't play nice with one another. You are not to knowingly harass each other with text calls, and you are not to do anything to disturb the other. The bottom line is stay away from each other. Let me tell you something, ladies. If you want to know what Chatham County really wants for you guys, is they want you to raise children who don't see this kind of silliness going on between the two of you. Both of them should be ashamed of yourself. I suspect you're both way better than this. I'm looking at the text between you guys. I'm looking at the fact that you go and you have a fight in front of your children. I mean, this is nuts. And so stop it. I'll just put the order in place, and thank you. That concludes this matter. We're going to move on to the next case.
This is nuts. Stop it. That's it. That was the judgment. This is nuts. Stop it. Yep. Don't worry. They're going to totally listen. Now, everybody pay attention for just a second, okay? This next one has some graphic words in it. They're not swear words or anything. Somebody gets cut deep on the cheek and some things show through. And they say it like 8 times, not even lying. So if that is too graphic for you, they say it in a little more detail. If that is too graphic for you, go away for 17 minutes. I just warned you. I told everybody. I'm giving you time to take your headphones off. Their teeth show through the cut on their face. Those are the words that they are going to say like 7 times, 8 times, 9 times. So if that is too graphic for you, go away, dip, bye. Fleischer comes on in, I don't know, 20 minutes. 20 minutes till Fleischer. Someone put a countdown on. All right, here we go. I warned you.
Thank you. All right, it's Judge Darcy going back on the record in the matter of the pretrial detention hearing of Keith Kaminsky on warrant 2024-0013490180. Appearances for the record.
Good morning, Your Honor. Erica Haleko for the state.
Good morning, Ms. Haleko.
Judge, my name's Kevin Moses. I'm here for Mr. Kaminsky.
All right, good morning, Mr. Moses. I provided you with the breakout room. Were you able to talk to your client about his first appearance rights and detention hearing rights?
I sure was, Judge.
Thank you. We can mark that as complete. At the present time, I'd like to mark the exhibits. I have the complaint warrant package, warrant 2024-001349-0180, affidavit of probable cause, preliminary law enforcement incident report. I'll mark as S1. I'm going to mark as S2 photographs sent to the court of the victim's injuries. Then I'm going to mark as S3 the PSA. The court's PSA was run on April 8th, 2024 at 8:35 a.m. It's a 1 for failure to
That means he's in jail, Kelly. He's in jail. There.
appear, a 1 for new criminal activity, no release recommended, charges including attempted murder. Ms. Haleko, is that your PSA?
Yes, it is, Your Honor.
Mr. Moses?
Yes, Judge, that's my PSA.
All right, I'll mark that as S3, and I'm going to mark the state's notice, motion, and certification as S4. Anything else to be marked, Ms. Haleko?
Your Honor, I did also submit a police report, but the state is not sure whether or not we'll be relying upon it for purposes of this hearing. I did provide it to Your Honor and to Mr. Moses.
Okay, I will mark that as S5. The police report is S5.
Thank you, Your Honor.
Would you like the court to move S1 through S5 into evidence for today's purposes only?
Yes, Your Honor.
Any objection, Mr. Moses?
No objection, Judge.
S1 through S2, S3, S4, S5 moved into evidence without objection for today's purposes only. Regarding the issue of probable cause, is that contested, Mr. Moses?
No, Judge.
All right, we all understand probable cause is a well-grounded suspicion an offense has been committed, and a well-grounded suspicion the defendant is the one that committed it. Court is reviewed S1, S2, S3, S4, S5. Court finds the defendant is an eligible defendant. Court finds probable cause for the charges. Moreover, the defense stipulates to probable cause in this matter. Ms. Haleko, I'll hear from the state on detention.
Thank you, Your Honor. I'll note that this incident did occur on April 7th of 2024, essentially when officers arrived. There were some 911 calls from the defendant, and essentially having arrived there, the officers encountered the defendant's mother, who stated that he's having some mental health issues. He has a knife on him right now. At that point, it's worth noting that the defendant came out with his right arm raised and immediately went outside of his house and plunged the knife into Officer Tarnow, slashing him in the cheek area so badly that you could see his teeth, and he had to be hospitalized. The struggle continued, whereby the defendant gripped the knife. He was on the ground with the officers for about over 3.5 minutes, as captured by body-worn camera, despite the officers telling him to stop and to hold on, and his parents pleading with him to stop what he was doing. He continued. He gripped the knife. He attempted to continue to stab the officer. After that, when the officer was able to get the knife out of his hand, he continued to struggle with the officer, causing him serious bodily injury and injuring the other officer there as well. I mentioned that.
I just need to cut you off for a second. The one who was struggling with him with the knife, was that a second victim of a stabbing, or it was the first one that fell to the ground with him?
The one that fell to the ground with him was the same officer.
Okay.
The officer who was headbutted and sustained minor injuries was not the one on the ground with him, Your Honor, for purposes of clarification. So ultimately, based on the 911 calls, what he said when he came out, his actions, the state would indicate that there's more than enough to show that the defendant's actions were intentional. There's attempted murder, various counts of aggravated assault, possession of a weapon for an unlawful purpose, obstruction, and possession, an unlawful possession of that knife. The reason I mention that, Your Honor, is certainly to indicate that this case is particularly disturbing. The body-worn camera, as evidenced by the police report and contained in the a depiction of it in the affidavit of probable cause, shows the defendant's actions that were particularly predatory. It appears that the defendant wanted officers to come to his house, hid by the door, and then, just went ahead right away and attacked this officer. He is in extreme danger to the victims and to the community based upon his actions. So the state is asking that he be detained for that particular reason. In addition, I think it's also worth noting that this defendant is a serious risk to obstruct the criminal justice system. He called 911 3 times, but with the intention of getting the officers there because, as he mentioned in the police report, he wanted to die. And then ultimately, upon the police arriving, violently stabbed and slashed the officer in an effort to attempt to kill that officer. So based on his actions, it would show that he's also a risk of obstruction to the criminal justice system. Finally, Your Honor, the defendant faces many charges here, including attempted murder, which is a first degree, and the state would submit is a heightened risk of failure to appear based on the fact that he is facing a lengthy state prison sentence with an 85% period of parole ineligibility. These defendants' actions are particularly disturbing, making him an extreme danger and obstructionist to the criminal justice system. Finally, this happened at his home with his parents present. I think that's worth noting. It didn't appear that anybody had any control over this defendant. And I think that that's worth noting, that it seems that detention is warranted in this case because of the defendant's actions. I'll note also he's pending a competency evaluation. We have not gotten those results back, but because of his predatory and intentional actions, the state is asking that he be detained. Thank you.
Ms. Haleko, is this a presumptive case?
It is not, because it's attempted murder, Your Honor.
Okay, thank you. Mr. Moses?
Thank you, Judge. We proffer the following. Mr. Kaminsky has lived in Atlantic County his entire life with his mother and father, where he still resides. Judge, he has an associate's in computer science that he got at ACCC. He's a couple of credits shy of his bachelor's degree at Stockton, but he's not currently attending school. Judge, at one point in time when he was 18, he was partaking in intensive outpatient for mental health issues. Judge, we would like you to consider that this is a Mercedes case. That this is a 1-1 with no prior history, and I know it's an attempted murder, but this is what an attempted murder looks like, and the case law and the algorithm take all that into account, and still he still scores a 1-1. There's nothing to aggravate this, Judge, to make you overcome that presumption of something other than the mere charge. I don't think an argument that this is a really bad attempted murder is an argument. It's an attempted murder, and just like any other charge, there has to be something more than the charge. So I'm going to suggest that you can put some conditions together, and we can release him. And we won't see any other issues. We haven't seen any issues before. He's 30 years old. So this is obviously severe and serious charges, but it's his first offense. So I'm going to ask that you release him with conditions, Judge.
Thank you, Mr. Moses. Before me in a pretrial detention hearing is Keith Kaminsky, warrant 2024-0013490180. Defendant is 30 years old, currently facing 8 charges: first-degree attempted murder, second-degree aggravated assault, third-degree ag assault, fourth-degree obstruction, third-degree possession of a weapon on unlawful purpose, third-degree resisting, and 2 third-degree counts of aggravated assault on a police officer. These charges stem from an incident on April 7th, 2024. Officers responded on a scene to 3 911 hang-ups. Officers called back and voicemail was left for Keith Kaminsky, the defendant. They went to defendant's home, where officers were met by defendant's mother, who stated, quote, "My son is having some mental health issues. He has a knife with him right now." Defendant walked out from the room in the home and rapidly advanced to one of the officers. The officers yelled, "Hold, stop," to the defendant. He then lunged on one of the officers, slashing his face with his knife, which is, I have a picture of, it's a serrated edged knife. And he slashed the officer's face with the knife. There was a struggle for several minutes, I believe 3.5. The defendant was taken to custody after the struggle. The officer who was slashed in the face suffered serious bodily injury to his face and throat area. He had a deep laceration in his cheek The skin was cut through and the inside of the officer's teeth were visible from the slash. Another officer suffered minor injuries from a bump on the head when he was headbutted by the defendant. Defendant has no pending charges at the time of the offense. He has no prior DP convictions, no prior indictable convictions. He has never failed to appear. He's not on pretrial monitoring, probation, or parole. He has no DV restraining orders against him. Defense argues his lack of history, that I could fashion something to allow him to be on the street. He lives with his parents. He has gone to college. He's only a couple credits shy of his degree. He's not in college now, but he did go for several years. When he was 18, he was in an IOP. And again, they want the court to deviate from the PSA because these are his only charges. The PSA gives a score of 1 for failure to appear and a 1 for new criminal activity. Defendant has no out-of-state criminal history, no violent criminal activity flag. PSA recommends no release for the charges to include attempted murder. Court gives great weight to the PSA. First, defendant may fail to appear. He's currently facing a first-degree murder charge, attempted murder charge, which comes with it a presumption of prison time subject to NERA. Presumption of 10 to 20 years. This may incentivize him to flee. Second, the defendant poses a significant danger to the community. Defendant is 30 years old, and the court understands he has no prior criminal history. But the facts are that the defendant lay in wait for the officers. He had 3 911 hang-up phone calls to the police as he laid in wait with a knife in hand and immediately attacked.
Jersey is different, okay? In Jersey, some people still have bonds because they had bonds before they changed the rules. And as soon as they changed the rules, anybody from there on out, they don't get bonds. There's no bonds in Jersey anymore, unless you already had one and things like that. So what they do is you are either detained or you're free. And if you're detained, you're detained until a superior court judge says that you can leave. If you're free, there's conditions or there's no conditions. So you can have, just PR, personal recognizance, you're free. Or you can be on level 1, level 2, level 3. Level 1 is like you call probation once a month. And then like level 4 might be you have to go into probation twice a week. So they don't have bonds anymore. They have released with conditions, and then they put these conditions on, but there's no money involved.
Attacked one of the officers, slashing his face so bad. He was hospitalized, required emergency surgery on his face. The slash was a long, jagged slash. The knife itself was a jagged, sharp knife. You could see the cut went all the way through, so you could see the officer's teeth. When arriving, the mom stated, "My son is having some mental health issues. He has a knife right now," again, which ensued the predatory and violent attack on the officers. They struggled with the defendant for 3.5 minutes in order to disarm him. He headbutted another officer. But certainly the one officer had serious bodily injury to his face and throat, deep laceration, which the skin was cut through, and the inside of the officer's teeth were visible with the slash. The other officer had mild injuries. This was an unprovoked attack. It appears from the evidence that he lured the officers to his house for the attack. The officer required emergency plastic surgery to his face. These actions also put his mother at risk. She was home at the time and she was aware of her son's possession of the knife and the alleged mental health issues. Mr. Moses believes that the court could put some kind of criteria or limitations on him. But it's clear from what happened that his mother could not keep him in check, that whatever happened at that house, she knew he had that knife. He's the one who was calling 911. She didn't call 911. He called the 911. And then as soon as police arrived, which appears to be as per his plan, he attacked and assaulted in a violent and predatory manner. So I don't know what conditions I could put on that he could go back to that house and the community and his mother and father, for that matter, could be safe. So based on the totality of the circumstances, the court finds him a significant danger to the community, to his parents, and to anyone else who he could be around. Lastly, defendant may obstruct the criminal justice process. He's currently facing third-degree resisting charges and fourth-degree obstruction charges. Defendant refused to comply with officers' commands on the scene when they told him to hold on and to stop. Defendant responded to these orders by lunging at the officer and slashing him across the face with his knife. Defendant has shown through his own actions he is not amenable to court orders. Therefore, based on the totality of the circumstances, the court finds defense, there is no presumption. Therefore, based on the totality of circumstances, court finds by clear and convincing evidence that the state has established a no bail, non-monetary condition, or a combination of both will protect the safety of this victim, other persons in the community, or assure defendant will not obstruct or attempt to obstruct the criminal justice process. Therefore, detention is ordered. You have 7 days to appeal, Mr. Moses. Anything further?
Judge, is there a court date?
Brad, do we have a court date?
Judge, I have June 5th.
June 5th. Before who?
Before Judge F team, Judge Waldman.
That's correct.
Okay, thank you.
Thank you, Judge.
Off the record.
Thank you, Your Honor.
Mr. Kaminsky, you can leave the booth.
Have a great day, Ms. Lego.
You too, Judge.
Thanks.
No bond, no release. He stays in jail. He's in Jersey. He stays in jail in Jersey. I don't know. I think his mom doesn't know what to do. I mean, how could his mom know what to do? June 5th. Rebecca, I don't know. Not all courts stream in Jersey, and I've never heard of that judge before. So I don't know if I can get that one. I just don't know. No soup for you. Oh, none of the young people understand what that means, Fleischer. All of us old people do, though. All right. We're going back to the same court we were just in. Not in Jersey, for the cat fight with the hats and people walking around. He's stuck like Chuck and Joycey. But this one's much shorter. And the reason why I'm showing you this is because I really don't think this guy knows what he just signed up for. It was the best episode, wasn't it? No soup for you. All right, here we go. Back to the other courtroom.
I need you to turn your picture on for me, please.
Yes, ma'am. Okay.
There we go. All right. Are you in a car?
Yes, ma'am. I'm pulling over right now.
Hold on. You do not drive through. You do not drive through my hearing.
Ma'am.
I thought I made that clear at the beginning.
Okay, I was, ma'am, and I leave work, so I have to drive back to my job, and then I have to get in my truck, and then I have to move it. So
if you were here at the courthouse, you wouldn't have had that option. So, I think you appreciate the fact that you didn't have to be here. Okay. So are you stopped now?
I'm outside the car.
Okay, you are welcome to sit in your car. It's probably more comfortable and a little easier to do that, but your choice about it. So this is Janae Rivers versus Sharif Marion, which is SPDR 2400659. And Miss Rivers, are you representing yourself?
Yes, ma'am, or either
Okay, I see here somebody from Mary's place. Are they helping you?
Yes, ma'am.
Yes, Your Honor. Our understanding is that Mr. Marion was just served this afternoon, like about an hour ago.
You don't have a lawyer. Okay. All right.
Our plan was to request a continuance. I don't know if he's in agreement with that, and if he is, we'll be then coming back. If
No
not,
problem. We're gonna try to.
I was ready to proceed.
Okay, we're gonna try to move forward with it if we possibly
Thank
can.
you.
Let's get both of you sworn in. So Ms. Rivers and Mr. Marion, if you will kindly raise your right hand, let's get you both sworn in.
So each of you solemnly swear that the evidence you shall give the court on the issue pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you.
Okay. Mr. Marion, I want to make sure, because you got out of your car, and I just want to make sure, are you in a comfortable, safe place?
Yes, ma'am.
All right, okay. All right, so, Ms. Rivers, let us see here. Are you asking that the temporary order be made the final order of the court?
Yes, ma'am.
I didn't hear you.
Yes, ma'am.
Okay, boy, I'm gonna have trouble hearing you. You're gonna need to, come say something again. Say that one more time.
Yes, ma'am.
There we go. All right. And Mr. Marion, do you agree to have this made into the 12-month order, or do you wish to have a hearing?
I got one request, Your Honor.
What's that?
Can we make this court order for life?
Well, you don't ever have to have anything to do with her, but for right now, this is a 12-month order, so it's 12 months.
I just know, Your Honor, we done been here before, and in the middle of a protective order, we both done went back down to the place and request that they drop it. Every time this protective order things happen, she gonna reach back out to me sooner or later. So I would just want to make it for life. So if she ever contact me again, when she get in a bind, she need help or whatever she going through.
Stop right now. I want you to stop, okay?
Okay.
What she is asking is that you stay away from her, and it sounds to me like you are agreeing. Am I correct?
I agree with you, Honor.
All right,
I
let's
ain't no
talk about
problem
what
with whatever she requested, we can do it.
Let's talk about what this is going to say. It's going to say then that that this order applies everywhere in the state of Georgia. It's in effect for 12 months, and that you have violated the Family Violence Act and you are restrained from doing anything harming her. And it is good in every state in the country and every county in the state of Georgia. Are we good so far?
Yes, ma'am.
All right. She is also asking for sole and exclusive use of the Winding Way property. Is that okay?
Yes, ma'am.
All right. She also wants you to stay away from her. And do y'all have any children together?
We got 2 girls.
Okay. So stay away from you and the kids. Any minor children? Are you agreeable?
Yes, ma'am.
Also says that you can't come within 500 yards of her, which is 5 football fields, meaning if you can see her, she is too close. Is that okay?
Yes, ma'am.
You also can have no contact, direct or indirect. We're having direct contact, but if I were to call your friend and tell your friend something to tell you, that's indirect, and you cannot do that either. Is that okay?
Yes, ma'am.
She is awarded temporary custody of the kids. Is that okay?
Yes, ma'am.
Okay. Let's see here. Neither of you are y'all married?
No, ma'am.
Okay. So I guess let me ask this of you, Ms. Rivers. Do you need me to stop the 2 of you from selling any property or canceling any insurance policies and things?
We don't have anything together, ma'am.
All right. So I won't worry about that. And do you have no ongoing relationship? Well, you do. You've got kids. So in theory that you do. So I'll have to put that in there about family violence. And anything else that you are asking for, Ms. Rivers?
No, ma'am.
Anything that you have a question about, Mr. Marion?
No, ma'am.
All right. All right. Well, this order shall go into effect. Do you have any firearms, Mr. Marion?
Ma'am, I'm a convicted felon, Miss Friedman. I don't carry firearms.
All right. In that case, you can't have firearms anyway. All right. All right. So I think I will find her to be. I can't remember. Did you say you are married or you're not married?
No, ma'am.
You're not married. Okay. But you are the parents of children, correct?
Yes, ma'am.
All right. With that, anything further then from either of you? All right, pleasure meeting you both. And that concludes this matter. Thank you.
Okay, thank you.
Thank you, Your Honor.
All right, anybody else on here that I have not reached their case? All right, who is Simone?
So I don't think he understands what just happened there. I think he's very confused. The order says that he cannot contact her for a year. He cannot contact her. The order does not say in any way, shape, or form that she cannot contact him. He's thinking that he's got her blocked from him, and he just doesn't. She can call him as much as she wants. If he answers, he's in trouble. I don't think he quite understood what he got there, but heck, you know, yeah, as long as he's happy, we're happy, right? Right, Cloud? He seems happy about it, Cloud says. And as long as he's happy, we're happy. All right, guys, it's time for Fleischer. It's time for Fleischer. It's time to go. Here we go. Going to Texas. We're getting out of Jersey. That was Georgia. We're getting out of Georgia. We're getting out of Colorado. We're getting out of Indiana. And and that girl's probably contacting him right now while we go to Fleischer. Here we go.
It's not that old of a case. It's right.
253 days. I would say it's old.
Well, I guess we came in, it's only 180 days for us, I guess. So I guess I'm looking at.
When is he going to have it?
I'm sorry?
When is he going to have the money?
We can come up and ask him, Judge, if you.
Come up, Miss Adams.
Wow, I say it's time for Fleischer and Victoria walks in. Oh, speaking of, everybody, there's a tiny little thing in this video. I thought I saw Victoria. So I typed in this thing, hi Victoria, and I cut that little slice of the clip out. Love, you can't be hungry at 5:46 in the morning. Go back to bed. That's my son, guys. Anyway, so I thought I saw Victoria. This woman comes up to the bench, and I saw this woman walk up to the bench, and when I'm editing, the whole editing program is big and the movie's like this little square. So I'm like, oh, that's Victoria. So I put in this thing, there's Victoria or something like that. Well, then this woman spoke. I heard her speak and it was like a real deeper voice. So I'm like, oh, that's not Victoria. And I cut that clip out. Well, apparently it only cut out the clip and it left the words. So just for a few seconds, you're going to see there's Victoria with blackness. And that's just how that's just, you're just going to have to get over it. Yeah, he needs his third dinner. Sorry. All right, Fleischer, here we go.
This way, Mr. Johnson. I'm taking the jacket.
Okay.
Sort it out. Okay. Who's just gonna ask you?
Within the next 2 weeks. Okay, that's it. If you don't have it within the next 2 weeks, all this goes away. Your case is 253 days old. I'm not giving you any more time after 2 weeks. If you don't have it done in 2 weeks, I'm going to set your case for trial. All this that you worked toward goes away. We cannot just continue to wait. You could have been done with this thing a long time ago had you been diligent from the start. Okay? I will give you the 2 weeks. I will not give you any more time. Understand? Okay. All right. Who else you got?
Next client is Mr. Blanco, Your Honor. I provided information to Mr. Petroff about the cancer diagnosis, and they're going to evaluate it to see if they can prove at the time of operation whether his BAC was 0.08 or higher.
Okay. It's only 107. I don't care what you.
I love it.
Whatever you want.
You'll say the same for Mr. Olivares.
Olivares. Same thing. I don't care.
Thank you, Judge.
Thanks, Herman.
I love it. He looks great, great, great today. Great.
I wear
John O'Shaughnessy.
Okay,
Yes, Your Honor. So evidence, the state just shared a good amount of evidence with us, but I'm also here to approach on his bond violation that was emailed.
The judge had a pretty good day.
Yes.
The judge had a good day today. Like, it wasn't packed. It wasn't a nut house. And he appears to be in a good mood. And I didn't see him rubbing his left eye that much, but I might have missed it.
John?
Go around. John, Mr. Moses.
wonderful, thank you. You were out at 3:46 in the morning,
That was very scary.
and I have here that you're consuming alcohol, Mr. O'Shaughnessy. 3:46 in the morning. How many DWIs has this gentleman had?
This is the second drive, actually on record.
Have you run an NCIC just to make sure?
Yes, sir. He's got two. And his last was 2015 in Harris County. All of his history is local, is what I see, Judge. Yeah.
What am I supposed to do about this, Mr. O'Shaughnessy?
I made a bad judgment call.
Okay.
And sir, I was actually on my way to work at that time.
At 3:46 in the morning,
Yes,
with
sir.
alcohol on board.
I didn't realize I had alcohol on board, Your Honor. I made a terrible, bad decision the day before. I consumed some alcohol because I had some root canal problems and I was in bed by 5 o'clock. And I don't know how anything could be there when I was going to work for 4 a.m. in the morning.
Deputy, he goes with you. Come on, that's it.
Yikes.
Talk to me back.
Oh, no, it was Melissa. Okay, I think I messed this whole thing up. Now I think I might have put Hi Victoria where Hi Melissa was. Anyway.
Good morning, Mr. Mays. How's jail? Really? So, Shreya, Mr. Mays is wanted from where?
Springfield, Illinois, Your Honor. Felon in possession of a firearm parole violation.
So you're on parole
Yeah.
and you're here in Harris County.
All my family's out here. I've been trying to get an interstate because my mom and my dad died while I was incarcerated out there. So I didn't have no family out there, nowhere to go to. When I got out, I came out here with my baby mama and my 3 kids.
And now, while you're here, you're actually out in the free world, right? Living like everybody else.
Yes.
And you now picked up an aggravated assault with a deadly weapon.
Me too.
And then 2 more felony gun cases. Let me ask you, you really want me to let you out?
That's I would like my freedom, yeah.
Guys, keep it down, plees.
So then
Let me ask you.
explained to her too the aggravated and one of those possessions.
I appreciate that, but we're not gonna do that.
I don't
right
want to
here.
talk about the case, but my concern is public safety. The only thing I care about are 2 things, Mr. Mays. Number one, that you go back to where you wanted from so that you can answer those charges, but more importantly, public safety, right? In this case, from what I've read, you wanted car keys and they said no to you. And what happened? You allegedly point a gun at them for the car keys.
That's not true.
let's not talk.
I don't care. I don't care, right? The fact remains you were still charged with it. And it's over and over and over. And what I fear is, imagine the kind of fear that your family lives with when you're around. Imagine the kind of fear when you walk to that door. Oh man, who do we got coming to the door today? Is he in a good mood? Is he in a bad mood? Do we have to walk on eggshells today? I wonder what it must be like to live in a family with you. When you walk to that door, who are they going to get? Are they going to get the nice guy? Or are they going to get Jekyll? Are they going to get Hyde? Are they going to get a gun in their nose? And you're on parole for another gun case. Let me ask you, do you think you deserve to be let out?
Yes.
Really?
Yes.
Why?
100%.
Why?
Because I'm not guilty. My baby mom been trying to turn in affidavits and everything.
Oh, thank you for that. But let's try to just keep it to the
Problem
charges.
is that it keeps happening over and over and over. So, Dave, how many priors does Mr. Mays have?
30.
Felony convictions, Your Honor. He has 3 felony convictions that I can see right away.
3.
A receiving possession
Sorry.
stolen vehicle, an armed robbery with a firearm, and a kidnapping, all within the last 5 years. Regarding other than the other felon possession of the weapon, the ag assault that Judge just described, on the newest felon possession of a weapon, he is admitted on body cam and on surveillance video with the firearm, which is a violation of his probation. So that in and of itself is a violation. And he's nodding, so it seems like he agrees that he just committed a felony.
So let me ask you again.
Just keep that to ourselves.
Do you think I should let you out? That's cute. Really. Because where you go, havoc follows. Sometimes we have to protect people from themselves because they're their own worst enemy. That's you, Mr. Mays. You got me bent 13 ways from Sunday if you think that I'm going to give you a bond with all that kind of history you got. Because I know if I let you out, you're going to do whatever you want to do, and you'll go like this to us.
That's on 14 day.
Yes.
No other reason for me to be here. Nothing else to discuss.
This one, he doesn't have the. I don't show that he made bond on the local, so the 14 days wouldn't trigger until he makes bond on them.
And we've advised him, you understand that until the locals get.
Yeah, you have not made bond on those cases. So basically here, this gets put on hold until you deal with all the stuff upstairs. And then at that point, right. But Shreya told me that you had stuff that you wanted to tell me that you wanted me to hear to try to convince me.
Just let me talk. Y'all both just told me don't talk about it.
Right, I don't want you to talk about the facts of the underlying case. This is pending in felony court, but you can talk about
why you want to let out. If you want to try to convince me, I'm okay with it.
There's no reason. You already told me your answer already. There's no reason. Just I'm ready to do what I got to do to get up out of here.
Okay.
There's no reason to talk about nothing else.
Jay, is there a waiver in place?
I can't, no, he refused on the 15th. So if he decides to waive now, then I'll email it to you.
Okay, please email it to
I never went in front of nobody to waive.
Okay, we'll talk about it.
I got reset 3 times.
Morning, Judge. How you be? I can't tell from the settings whether or not, because it looks like he was waived on May 9th.
No, May 9 was on the book.
Yeah.
Why?
This is new law violation and no appearance.
Oh.
What are you, Mr. Nakin?
So I think what happened is he was waived on May 9th. I think he revoked because of the open tubing.
Do me a favor, will you guys switch?
If I can, Judge, I always try to stand between to protect him from him. It's forcing habit. If he wants to hit me, that's fine. If he wants to hit him, it's a whole other kettle of beans.
So
Felony. Yeah.
I don't think Mr. Nakeen's going to do that.
I don't.
Would hope not.
But I take the philosophy that I do it in every case, if I can.
Okay, so I have here, so we're on bond for a harassment case. It looks like you've now picked up a new case. Looks like you've picked up a violation of a condition of bond. I don't know anything about it yet. So we're now going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay, so let's go through the original harassment. What happened?
The original harassment happened in January 18, 2024. It was a officer dispatched a burglar of the residence. Officers arrived and met with the complaining witness and other responding units. Complaining witness stated that she and the defendant, her husband, had been married for approximately 8 years, but are currently separated and no longer living together. As they were getting divorced, the complaining witness advised the defendant showed up to her residence, broke the lock on the gate to her residence, made entry, and began banging on her door. The complaining witness stated that she heard the defendant say, "You stupid bitch, and I'm going to get my ex to whoop your ass."
Okay. So that is the original harassment. I got to say, I probably issued a no contact order. Probably issued a protective order as well. Right?
That's right.
And so what happened with the newest case?
This case was on 420, April 20th, 2024. Officers met with the complaining witness who stated that the defendant contacted her through Snapchat on April 15th and April 19th, 2024. On April 19th, 2024, while the complaining witness was at work, the defendant sent messages through Snapchat stating, "I walked in the parking garage and did not see your truck. Where was your truck? You keep avoiding. F you, I'm done." Snapchat username was Quinn77, whereby the complaining witness is contacted and shared pictures in the past of the defendant through that username. The defendant's additional to that, the defendant also stated to the complaining witness calling her a white bat, and the defendant's bond conditions prohibit harassing communication with the complaining witness. Complaining witness ID the defendant via mugshot and driver's license photo.
Okay.
Besides the fact that the mugshot and driver's license photo has nothing to do with Snapchat. I don't contest the facts, Judge. It's just you can't prosecute it under this offense.
Let's have a hearing over that, and then we'll see if we can have just, like a short probable cause or a hearing as to whether I'll grant your motion. So I guess get ready, get your argument, get your case law ready as well, and then we'll have a hearing, and you can have Thursday or Friday, whatever you want, and then we'll come back.
Judge, if I may, noted, I think the most appropriate remedy would actually be a quash because they don't really know what's the ready to argue for.
So follow the appropriate motion. And then
I will turn my verbal motion into a written motion and file a written motion to quash it.
Yeah, that'd be great. And then we can have a hearing over it.
That's fine.
If he's in custody, we'll do it sooner rather than later.
If we could do Thursday instead of Friday, I'm trying to go to Crocodile Encounters on Angles, of course. Thank you, Judge.
Anytime. All right.
Thank you.
I would like to do now will you file a new MOA? Stephen, don't send them down because I'm going to do a MOA later.
I feel like a whole one.
They already is doing it.
Yeah.
Did they do a new one on the,
and I will renew that stupid argument. Because why would you do it?
Fully noted.
Well, why would you do a MOAP on a violation of a protective order case? Like there's already a protective order.
Fully one.
Yeah. It just angers me because then you never know, like the cops don't know there's two sets of rules.
He smiles a bunch today. A bunch.
Yeah. I'm the one that the cops call different set of cops. I'm the one that the cops call and be like, what should I do? And I'm like, well.
So just set it to Thursday and we'll do.
Will do. Thank you, Judge.
For sure. Lisa, you ready? No, wait. Don't go anywhere. We need you for one more. Okay. Lisa, you ready? Yes. So you want a cause number?
Yes.
It is 2510-530.
She's here. She's coming back in the court.
We're waiting for you.
The bail bondsman is on his way up. So.
Do you have any proper?
No, nothing. Okay, perfect. Thank you. I'm used to felonies where you can't.
But around this way.
Hi, Lisa Strauss. So this happened in Montgomery County, weirdly, in a hospital in Montgomery County. So you might want to look into that.
You, Monica Villarreal?
Yes, sir.
Kelly, answer. I don't know. Is Houston in Harris County? I know it's in Harris County, but I don't know what is in Harris County. But don't worry, Kelly's here. Kelly will answer.
Ma'am, you stand charged with the offense of assault of a family member. This is a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions in any abuse of the state of Texas. If you cannot afford a lawyer will be appointed to represent you. Please don't say anything.
Okay, April 24, 2024, officers followed up on
It's Houston inside Harris.
On April 18, 2024, officers spoke with a complaining witness who stated that at 2001 Ladbrook in Kingwood, Texas, the defendant, his ex-wife, was upset that he was already in the admittance process at the hospital after she arrived. The defendant slapped the defendant in the mouth with her hand, causing pain. The complaining witness ID'd the defendant via a photograph. The officers obtained a video footage of the incident that corroborated the story.
So he's in a hospital being admitted?
No, their child was being admitted to a mental health facility, and they're divorced and they were having a dispute over the child. And so, and actually this happened in Kingwood, Judge, which is in Montgomery County.
Is that true? Let's see. Where did this happen?
So this will be the final summary of facts. The incident occurred in Harris County, Texas. I, Officer Amber Wright, declared the penalty of perjury that the foregoing is true and correct based on the information and belief. That's part of the death.
Do you want me to look up the address to see? I mean,
it's our understanding it's Montgomery County, but I don't know how it was filed here, but it just.
Lisa, so Damien, where did it happen? What
2001 Ladbrook.
2001.
His father.
Ladbrook.
I see it, Kingwood, Texas. I mean, it's an Humble. It's like right out of like 2 minutes out of Humble, right? In Tascasita.
Yes.
That's Harris County. No?
It is, but when it's considered a hospital, the jurisdiction is not, that's not what the.
No. What matters if it's it's in Harris County. I don't care about laws and this and that. My only concern is it really in Harris County?
Or Montgomery County.
Or is it in Montgomery?
Montgomery County, it's Kingwood Pines Hospital, mental hospital. Kingwood Pines Mental Hospital.
I don't know. I think
April
it's Harris County.
No, not the date, doesn't matter.
Okay.
Just, it's okay. I'll look into it.
Look into it.
Yes, I'll look into it.
And if it's truly in here, if it's in Montgomery County, then it should have been filed in.
Yeah, it's okay. Just leave it alone.
Let me tell you something.
We'd rather it be here than
leave it alone. Be careful what you wish for.
Yes.
Really.
It's easier to handle here than Montgomery.
Really? Okay.
I do know that.
Okay.
Go ask around.
Yes.
I promise.
We'd rather
I
be here.
know. I've heard.
Yes.
Yeah. Right. Okay.
Yes. When I heard Kingwood, I was like, that is Montgomery County, so that's why
I don't know. Maybe some parts are in.
Yeah, I'll look into it, but just don't say it's okay.
I don't know, but Harris County handles a lot of things differently.
Yes.
Criminal cases versus Montgomery County. I'll tell you that.
I've heard.
So for right now, I'm gonna find that there's probable cause. So
approximately like not even a mile away from Montgomery County.
Okay.
It's still in Harris County.
okay. So my question now is, do you have a rip done?
No, I do not have a report yet on this, Judge.
So is this,
They're divorced.
okay,
They've been divorced for 2 years. They share custody of the children.
Okay.
And this was an issue involving, the
guys, keep it
hospital.
down, please.
The hospital is the hospitalization of the child, not of the defendant. I mean, not of the complaining
Right.
officer.
How old is the child?
12.
No, to be 12 August 1st.
Yes, almost 12.
Okay. Do you have primary custody of the child?
I have primary residence and, just for school.
Yes, who has primary custody?
Typically, in these,
Looking for primary conservators. I'm the domicile. I'm primary domicile. I wanted primary mental because this is the second time that she's been in the
Attempted
hospital.
suicide, yes.
Yes. And
no, my concern usually because of these high stress situations, I usually order no contact with the complaining witness in this type of case because, you know, it being that it's even more high stress, that's only going to add to the frustration, and I don't want anything worse to happen.
she was already in custody. She didn't witness any of this. And
No, he's not saying no contact with your child. He means no contact with your ex.
Oh,
That's
yes,
no
my-
contact with the ex.
Amy said to speak with you about that. We have a go-between, that we have had, or she's like, she's the babysitter, like a nanny, but
That exchanges, that you exchange the children through?
yes, ma'am. And she's been with them both since they were 6 weeks old. She saved my son's life when he was choking. And she is actually, she's like their grandparent. I don't want to say anymore.
Okay, that's fine.
Is the child currently still hospitalized? She's out?
She's out, but,
Still having issues, yes.
well, I don't know what else I can.
No, that's all. It's
I mean, we don't need to know.
Comply with the medication. I've had to go and get the medication on his possession. Sneak it into her because it's a psych medication for her not to kill herself.
So the complaining witness you're saying is not administering the medication to the child as needed.
But, and he cussed her out and it's in a text from her. And
So-
he said, I'm not paying.
Thing is that, ma'am, in these types of situations, what you need to do is you need to go to the felony. You need to go to the family court.
I haven't.
Yes, and that's,
Already have.
yes. Yes, she's working with a family law attorney.
You
Yes.
need to go to the judge and say, look, judge, this is what she needs. If he's not in compliance, then you take
Yes.
I have
She's
it.
gone back to the
Patient
family.
away.
I have it all on our
Yes.
family wizard. I had that.
Yes, she's gone back to her family law attorney and they're working this.
You
That's
cannot take matters into your own hands because you're the one that's going to go to jail. I'm ordering you now not to have any contact with him. You understand?
Yes, sir.
I don't care how stressful it is. When I mean no contact in any way, no text messages, Snapchat, phone calls. The gentleman that was just here now, same thing, Snapchat messages. Where is he now? He's in custody. I don't want to have to do that.
But I do want to.
Can they communicate about
record.
the exchange of the children through family law, the wizard? No.
I mean, no contact means no contact at all.
Okay, today he gets back possession. How do I?
I would use your nanny as the intermediary.
Yes.
She's the one that can have contact with him. What's the nanny's name?
Linda?
You contact Linda, tell Linda what to say, but I
Tina.
don't want you to have contact with him at all.
I just want to,
That's
on the record,
on the record line.
if my daughter dies, it's on his hands.
There's nothing, we can't get that on the
Go
record.
to the family court and ask for an emergency motion and an emergency hearing immediately. You can do that.
Okay.
They have ways to get to a judge if
I'll go
there's an
today.
emergency,
I'll leave today. Here,
really. But
there it is, my container.
don't take matters into your own hands. It's really going to go sideways. And imagine what's going to happen if you go to jail. What's going to happen to the 12-year-old?
And they have a younger child too, as well. Yes. Okay, we just have to handle it through the proper channels. He just wants to make sure you're handling it through the proper channels.
It's okay. You'll get through this. We just need to find a proper avenue to get through it so that everybody gets attention. And I'm telling you, if he's not doing the way that he should, the family courts should help you out. Lisa knows how to handle these things. If you ever have any issues, talk with her. All right.
And I'm in communication with her family law attorney as well. that Ned Gill, that's who referred her to me. So we're in communication. So we will
Feel
get
your
this figured out.
pain, and I just don't want to add to any more of the stress, but I think that if you just kind of break away from this individual,
yes,
hopefully good things will happen.
Yes.
All right, I'm going to set your bond at $100. I will give you a PR bond today. I'm going to tell you now, Ms. Villarreal, I will not give you another one. If you violate these conditions, if you pick up a new case, I will put you in jail. You will not get any more PR bonds. The only thing I'm asking you to do is don't have any contact with this person. That's it, and no weapons.
I understand that.
You ever have any issues, talk to Lisa. I know her well. She can come to me and we can hash these things out.
I already took away Reese's phone because she kept asking questions. Okay. I couldn't answer.
Yeah, any issues, just talk with Lisa. She can, Damon, anything else? Do you mind filing the order for no contact, no weapons, please? One more thing, I am going to issue a protective order, okay? This is a protective order that identifies Ruben Villarreal as a protected individual. You cannot commit family violence or an assault, no threatening, harassing communication. You cannot use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where he lives or where he works. This order is good for 61 days from today. If you have any issues, like I said, Lisa can get a hold of me. We can iron these things out.
Exchange the kids through a third party, through Linda.
That's fine.
Okay.
Right.
We were doing that anyhow.
Okay, good.
Okay. Questions? Okay. If you do, like I said, she'll get a hold of me and then we can hash these things out. Do not leave because we need to sign. We need to have you sign a bunch of paperwork. Now, one more thing. Because you have a representing you, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Ms. Strauss.
She will.
She'll tell you if and when you have to come back to court. Don't go AWOL, otherwise I'll issue a warrant on it. Okay? I believe that. Okay. Thank you, Ms.
Okay,
Thanks.
thank you.
Anything, man. He's playing games. Good morning, man.
This is the Cephas, Your Honor, for a plea.
I'm Ms. Cephas.
How you doing today, sir?
Ma'am, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you
days.
Cephas, please.
4 days with 14 days credit.
4 days in jail with, I think you said 14 or 14? 14 days credit. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this. Is this what you want to do, ma'am?
Yes.
How do you plead to the offense?
Guilty.
I will find you guilty. Send you to it. Good luck to you, man.
God bless you.
You too. Take care, man.
Thank you. God bless you.
Hey.
Judge, do you need a Mr. Mace to admonish him about the waiver? He signed it.
It's okay. We don't need to.
Okay,
I
thank
get
you,
it.
Judge.
Yeah, for sure. Hey. Hi.
I have Mr. Emmanuel Edens. I have Mr. Mark White and Mr. Braden Hill. These are interns that are going to be working with us this summer.
Fantastic. You have
And I
people
wanted
help
to
you
introduce
out?
you. This is Mr. Kevin Jones, and that's Bella Petrov.
Hi, guys. Good morning. Welcome. You have help now?
Not
Yes, I
at
have
all.
help.
Hey.
With Mr. Edens, we're
There's a chance this case could go on.
Okay. Take your time. I mean, there's no, he's not going anywhere anyway, right? So we'll set it off like a week or two, talk to him in the interim, perhaps. And, okay. Are you Mr. Edens Emmanuel? Good morning, sir.
How you doing, sir?
Guys, keep it down, please. So you were charged with a murder case.
Yes, sir.
You're out on bond for a murder case, right? Which I got to say, you're probably lucky as it is to be out. And now you pick up an assault of a family member. Don't say anything because I don't know anything about your cases. We're going to do probable cause because I got to get to know you now. You're charged. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present.
I got this, Victoria. Don't worry. I got this. She had to put more electricity inside of it.
If you cannot afford a lawyer will be appointed to represent you. Okay, so let's go from the top.
Yes.
What happened on the assault?
On March 26, 2024, in Harris County, Texas, officers were dispatched to an assault. Officers met with complaining witness. Defendant and complaining witness got into a verbal argument while defendant was driving. Complainant wanted to exit the car, but the defendant wouldn't slow down to allow her to get out. Complainant broke defendant's rearview mirror. Defendant punched the complainant several times in the face, causing pain. Complainant was finally able to exit the vehicle. Defendant sped off and complainant called 911. Officers noted that complainant had a large welt on her cheekbone. And you know his history.
So what happened on the murder case?
It still looks like, as far as the murder case is concerned, it looks like it's still pending. It's a felony indictment. Yeah, still pending, Your Honor. But that just the facts of that case, it appears that it was good. It's like on October 19th, this was actually from 2017. There was an investigation regarding an assault which occurred between two inmates in a holdover cell at the jail facility at 1200 Baker Street in Houston. One of the inmates, identified as Lloyd Allen Mosley, had been transported by EMS to.
Okay, so it was a jail murder? Is that what it was? Okay, Mr. Manuel, I think that you're an extreme danger to society, man. I really do. Your bond is set at $10,000. I don't even think that's enough. I'm going to raise it up to $30,000. I think that you were lucky to be out. Now you pick up a new case and you're on bond for a murder case. I don't think so, man. I think that you're a very, very big danger to society, and I'm going to raise it up. I don't think 10,000 isn't.
According to the murder, further states in here that they saw surveillance camera look like that the defendant Edens was trying to get the attention of officers because of sexual advancements in the jail, and then they learned that he had several lacerations to the face. So according to the accusatory document here from the officer, it appeared that the inmate Mosley had neurological injuries sustained in the assault.
And then I guess I would say succumb to those injuries. Yeah. Mr. Emmanuel, I'm entering in what's called a magistrate's order for emergency protection. That is a court order that identifies Nikedra Winston as a protected individual. I know that one was issued, but I'm updating it for today's date. I'm finding that this person is a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Only one more thing I'm going to tell you. The jail calls are all recorded. So I will be very careful what you do, who you say, and who you talk to. I'm telling you not to talk to this person now. I'm entering in this order for protection. If this person should call you, I wouldn't accept it. I wouldn't talk to her because you're the one that's going to pick up the violation of the protective order. And I'm telling you now, I don't care about anything in this life but public safety. And if I find that you violated a protective order, I can have a hearing to hold you at no bond, zero bond, and I'll do it in a heartbeat. You understand, Mr. Manuel? Thank you.
The rip was done.
Okay. I'll let them get to it. Then he's going to go talk to the domestic violence division. I'll let them handle it. I think that the bond is insufficient. You scare me, Mr. Manuel. You truly do. So, all right.
I don't know if it's just a camera, but this guy looks so tall.
You know, I am very reluctant to do these BIP and dismiss classes because they're so very difficult. It's a batter's intervention program where you were supposed to go once a week for 18 weeks. And the problem is that 90% of the people just don't care and they don't do it. And so we try to maintain a close watchful eye to ensure that people don't play games with us, because I don't like to play games. I have 2,500 people on the docket, and I try to move it because justice delayed is justice denied, right? You were given this offer in February. I expect you immediately to get on it. And when you don't, that tells me that you just don't care. I expected you, when the offer was given, to immediately register and begin classes, right? We gave you until March to provide proof of enrollment. March came, and I guess nothing happened. We are now in May, and you haven't done a single class, have you? That's not good enough. You were supposed to be at least halfway done with the 18 classes. You haven't even done one class. So it's over. You cannot. No. You've had 3 months from the time that you were given this offer. You've done absolutely nothing. I've got way too much drama in my life now. I don't need any more. You know, if you really would have cared, you would have done something a lot sooner, not 240 days later. This is, I'm not here to just, you guys can talk, figure out what you want to do. Then I'm not going to sit here and hope that you continue to have money and not do anything. You're supposed to be a working man. You're supposed to be earning a living, not bumming your way through life. There are consequences when you don't work and when you don't do anything, right? And I've told you that since day one. Day one, when you got here, I told you to get a job. Don't you remember? When you put your heart into something, you can achieve damn near anything. That's the way life goes. If you don't put your heart into anything, you're not going to get anything. That's the way life is. But whether it goes with work, whether it goes with school, whether it goes with child rearing, when you put your heart into it and when you really care, you can do anything. Me.
That's why he's mad. That's why he's mad. He's mad because this guy could have easily dug himself out of this hole and got a job and done something. That's why he's mad.
If I can become a judge, and I was about one of the worst students out there, but you know what? I had heart and I had drive and I really cared and I wanted to change the criminal justice system, you know? Me, inch high private eye, you know? I worked my scheisse, really. And I'm telling you, when you put your heart, you can do anything. Mr. Henry, you have shown me that you don't care. So that's it. Do you have an alternate offer in this case? Henry.
6 months deferred adjudication.
Okay.
Also,
you guys go talk about what you want to do. I'm not going to sit here for another 18 weeks when you've been already given 90 days for it to at least have half of it done. So please tell me what you want to do. If not, I'm going to set your case for trial. Hi. Come on.
Judge, I'm here on Moya, M-O-Y-A, Benjamin Moya.
Okay.
The DWI judge.
Yeah, tell me where you at.
Trez, I've submitted the completed application.
Okay.
Chief and I both wanted me to submit a mitigation package to meet Nathan Beadle. That has been submitted, Judge. It was several days after what I wanted because he owns a business. We want to get some records from his businesses supply us. We got that eventually after the storm. And the bookkeeping ran out of power for several days. Nathan Beadle has it. The chief has it.
Have you submitted everything that you?
Sure.
Everything's been submitted.
Everything's been submitted.
Has he done the TRAS?
TRAS has been done.
Okay.
He went right after court last time. Completed PTI packet. Chief wanted me to submit it. Last time, Chief wanted me to submit a mitigation packet with Beadle. Beadle has it. Chief has a copy in their mailbox.
So let's, I guess we're waiting on a response from Beadle. Is that what we're waiting on Moya? Sorry. Moya. Are we just waiting on a response from Beadle?
I emailed a copy to Nathan and a CC copy to you.
He will be back. He's some more situations, some more things.
More?
Yes.
But wait, I have more things?
He will be back.
Excuse me, what? I didn't hear what he said.
They want you to provide more documentation.
Oh.
What else does he want now?
I was checking my email as I was walking up.
It says, this is a DWI second, you are missing the following, a letter from the client. Needs a letter from the client.
Is that the last thing?
Yeah.
Okay.
The letter from the client, Judge.
Yeah, I guess today's Tuesday. We'll set it to Monday. The letter's got to be, is there anything else that needs to be submitted?
For Beadle, that's it.
So we'll roll it to Monday. Your client must have it submitted by Monday.
It'll be submitted well before then.
Okay.
It's a holiday, it's Tuesday. It's a holiday Monday.
The Tuesday. Okay. Thank you. Yeah.
The one in the queue.
Yes.
Okay. Done.
Dígale, Mónica.
Good morning, Your Honor.
Hey, good morning.
May I approach via Zoom?
Yes, ma'am. Please. Sorry to keep you waiting.
No, no worries. I'm here. My name is Attorney Longmiles. I'm here on Mr. I.C. I just emailed Mr. Jones, 88 Jones, about a possible PTI offer for this matter.
It's only 83 days old. You just want a normal reset, right?
Yes.
Okay. Bear with me a second. Let me get you a date. I see. ASSI. I don't know where Victoria went. She's talking to someone? Bear with me a second, Ms. Longmiles. When I get her back, I'll get you a date.
Okay, thank you.
She wants to apply for a PTI. ASSI, but it might be with, is it with vehicular or is it with you? Okay, that's good news. You okay?
Problem solving.
No, I guess finish it, and then I need a date, but finish your doing.
Okay.
You put a PTI offer? Okay. They put a PTI offer on there, Ms. Longmiles.
Okay, thank you so much. And the new date, wait on it.
Hey, give me a second because I'm waiting for Victoria to get back. She's on the phone.
Okay, thank you.
Or you know what? Why don't you do this? Just email her. We'll get you dates.
Yes, sir.
Yeah?
Will do. Thank you.
Yes, ma'am.
May I be excused?
Yes. Have fun.
So you're gonna do another small one for next one?
She's gonna get up.
There was already one done.
On 19, yeah. Do you know how to?
Okay, I cut it before she got up. She stood up.
Good morning, Mr. Moses. I brought you out here because I want you to, since these are your cases, it's only fair that you hear what's going on, okay? So.
Order in the court.
Mr. Moses, I want you to understand.
It's the judge. You don't need to be looking around, sir.
There's nothing over there for you. So my number one concern is public safety. And if you are going to endanger her, I'm going to do everything in my power to take you off the street. You were on bond for an assault and you were let out. You were in the free world. I see that now you've picked up another assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I don't know anything about it. And I don't remember even what happened on your first assault. So we're going to find out and we will now see if you were a danger to the public. So can you please read the new one?
The new one first?
The new one first, please. Yeah.
So on May 16, 2024, officers were dispatched to a disturbance with an unknown weapon at 2108 Gessner Road in Harris County, Texas. The complainant witness is a mental health tech and is an employee at the Houston Behavioral Healthcare Hospital. The complainant was moving the defendant to another unit in the facility that was more secure, that has more security and staff due to his behavior. Defendant struck the complainant in the left side of his face with a closed fist. The complainant felt pain from the assault. On the way to the other unit, the defendant struck him again with a closed fist on the left side of his face, causing pain.
Okay, so what happened? The first assault.
And on 3 days prior, May 13, 2024, officers were dispatched to the disturbance at a family violence at 8323 Cinnamon Lane, Unit 1001 in Harris County, Texas. The complainant is his mother, who came home from work with food. And while the complainant had showered, the defendant spilled the food on the floor and left it.
He spilled the food on the floor and left it?
Left it on the floor. So the complainant confronted the defendant about the spilled food, and the defendant began to strike the complainant on her face with his fist, causing pain.
Judge, if I may kind of help you out here, you should have before you a request for competency with Mr. Moses here. He has informed me that in my conversation with him that he has attempted suicide on at least one occasion, that he has been institutionalized at the Bentov mental facility, and that he suffered from schizophrenia. He's paranoid schizophrenia, and he's currently taking
the concern is, why does it keep happening? Why the constant aggression, Mr. Moses? Why? You have, before this, a month ago, you had a felony assault of a public servant dismissed, a harassment of a public servant dismissed, attempted harassment in a correctional facility that was disposed of, and then an FSRA. Why all the aggression? What happened?
If with all due respect, I believe that once we have a common examination, I believe that some of your answers will be resolved here.
I'd like to know what happened.
Yes, sir.
As it stands now, Mr. Moses, I think you're a big danger to the public, man. It's not going to stop. You won't talk to me, so there's no way that I can figure out how we can get this to stop. So I'm going to revoke your bonds. I'm sorry, Mr. Moses, but on the new assault, it's set at $5,000. I guess that he had gotten a PR bond on that one.
I believe that's correct.
Yeah, I'm taking the PR bond away. We have to find out why these aggressive issues keep happening, man. And at that time, once you learn to cope with this, hopefully we can let you back out. Okay.
Thank you very much.
Thank you.
Yeah, I renamed all my little kittens. I have a Fozzie, I have a Kelly, I have a Cloud, I have a Carolyn.
Morning, Mr. Briscoe.
Good morning.
What's jail?
It's the same. I don't usually come here. If you look at my record, no felonies, no misdemeanors, but currently I'm being harassed by a group of white.
Felonies?
Oh, of course not. No, I'm being harassed by a group of white and Spanish terrorists that seem to work for the police department. Every month I seem to have an incident with a misdemeanor charge, and I am schizophrenic. So, they try to use knowledge as if we can follow them. I see them following me all the time. So they use that knowledge to say, who's going to believe a schizophrenic? So I see them following me all the time. Unmarked cars, marked cars. I'm over there right on LA and Greenspoint. I see them all the time.
So one more thing.
What's that?
Don't smoke weed if you got that problem. It's only going to enhance it, man.
That's the thing. Delta 88 is illegal weed here in Houston.
Right.
That's correct. I do.
Use, because you got these issues. It's going to make it even more. It's just going to it's going to compound it worse.
Well, when you have a group of different colored terrorists all trying to compete for the best terrorists, sir, and people are using their job to compete with me, and I don't use a job to take advantage of someone, we have an uneven playing field.
Okay. So you're on bond here. What I see that you picked up yet another felony, a retaliation case.
Oh, that's a misdemeanor. The retaliation.
No. It's a felony.
Oh, I'm taking it to trial, sir.
Okay. So all I wanted to do is bring you out here now. You have an open case with us.
That's correct, sir.
I'm yanking that bond now. You were given a PR bond, but now you done picked up 2 felonies. Can't do that.
That's fine, sir. I have a good lawyer and I'm sorry, go ahead, sir.
No, it's okay. I wanted to let you know what's happening here. It's only fair because it's your case. So
What would you set the new bond at, Judge?
5,001.
Could we do maybe 1,000? He's gonna have to make his bonds in felony court.
No, okay. I mean, he picked up 2.
I'm being harassed. Are we taking that into consideration?
Well, perhaps here now you're safe.
How long are you safe around the people that affiliated with harassing me?
I don't know, because we can put you aside. When is he in court?
I have a court date on the 20th, this month on the 20th, sir. My lawyer wants to combine all court dates and we can handle them at the same time if you want to issue that, because I have a good lawyer, sir. He's an ex-NFL player.
That too.
Yes, sir. We can do all of that.
You want to put it on the same day, Judge, or?
It's May 28th.
Well, we'll do the day after. Because you have felony court upstairs, we can't have you here both at the same time.
That's
We'll
fine,
just put
sir.
you for the day after. I just want to let you know what's happening with the bond since it's your case.
Just to give you a little recap, sir, I was at Urban Air. How violent can I be at Urban Air with my son, sir? The guy's on me grabbing his gun in front of my son, asked me to leave after I just paid $25 for my son to swing and jump on the jump. But it all originated from a Spanish lady telling him I was a problem because I was trying to record my son. And then he just started following me the whole time in Urban Air. Waited till he heard something. He put his hand on. I say, "Sir, you're not the only one with a gun." He arrested me. Hey, gun, and then arrested me. That's how the whole thing started, and that's how it ended. So if I committed a crime, I would say I committed the crime.
Be careful, all right? I like Urban Air too. It's a great place, all right? Okay, so just want to let you know what's going on, okay? But take care and be safe.
Yes, sir.
Thank you, Your Honor.
So the real tall guy went away to decide what they were going to do, whatever. I have him. I stopped the clip here, but I have more of him. I'm not sure when I'm going to play it, but we will see him. It's probably going to be like Saturday or Sunday when the judge isn't working. The judge just kept rolling. He kept rolling through. This guy spouting off all this crazy at him, and he just kept rolling through. And yeah, that was Sarah when he said you're safe here. He didn't agree with him, but it was awesome. He needs meds. He definitely needs meds. Something. Absolutely something. Could you imagine being there when I don't know what happened at Urban Air, but he just said that he pulled out his gun and was like, I have a gun too. What? Kids play there, right? Don't they? I've never been to Urban Air. And I have an idea of what it is in my head, which is probably way wrong, but in my head, yeah, all the meds. All the meds. Like I'm really impressed in Judge O'Donnell's courtroom when he asked them what their meds are, and they just like I take meds, and I couldn't tell you what any of them are. Oh, well, meloxicam, I can tell you that because my knee is 90 years old. That's the only one I can tell you about. I don't know the names of my meds. They all know the names of their meds, all of them. I cannot pronounce that. Oh, Hedwig fries again. Yes, I can. Oh, oh, poor Hedwig. Now I'm sad. I hate owls, but I do love Hedwig. All right, guys, that's what I have for now. Champagne? I don't know that pill. Champagne. Champagne. I'm gonna drink some champagne later and try to figure out this word. No. Mm. Where can I get it? I mean, that's really nice. That's good. They scare me. It's not my fault. I was born that way. But not Hedwig, although I do close my eyes at those parts. Yes, yes. You know how I hurt my knee, honey? Here's what happened. My son was in the living room like a couple years ago with a girl. Rebecca, stop. Don't stop. My son was in the living room with a girl, and I was trying to sneak quietly down the stairs, and I missed a stair, and my body went, but my leg didn't. My leg didn't. So ever since then, I take Meloxicam to try to get my knee to work again. Thanks, Diane. Thank you. My son, my boy, my Anthony, who just made macaroni and cheese and didn't give me one noodle. No, there's not a noodle. I mean, there's not a video, Carolyn. Oh, okay. Not, I don't know what an urban area is, but here's what I think in my head. And then someone in Texas will tell me if I'm wrong. I think it's one of those machines with the fan in the bottom, and you get in and you can like fly on the all right, Googling. Urban Air Park. Oh, it's trampoline. Never mind, you jump. Jump. Come on, jump. You just jump. That's all you do. No, I can't. Well, okay, I can because, I drink a lot, but I'm not going to. Yeah, so I was wrong about Urban Air, but I'm going with my Urban Air because it sounds way more fun. I don't have to know my medication to get refills. They just tell me when it's ready and I go and get it. Less traffic, better parking. I live in the country and then the air is not great smelling. It's never is great smelling. You walk out the house. No, sir. I used to live right by a stockyard too. I'm still here. The stockyard shut down, but that air was not good. Not good at all. All right, guys, take this all to the Discord and keep talking. I say that every day, but no one does it. People do talk in the Discord a lot, but they don't take this to the Discord. They intermingle. Say like, there, I just sent a secret message to everybody in Discord. So you have to get in Discord to talk. Cloud, thank you. You do so well. My mods are so good. They really are. I pity all the other YouTubers. Victoria, you and Melissa have a great day at work because we'll be watching. Don't let the judge alone again today. You see what happens when you leave him alone. If you leave him alone, give him a little post-it note on his desk. Like, if you can't find Victoria, sit and wait. All right, guys, have a great, great, great day. I will talk to you again tomorrow. See ya.